Welcome back to the deep dive. Today, we're really diving into a case where um, a very personal, very difficult story collided head-on with some fundamental questions about law and justice.
Yeah, we're looking at IMM v. the Queen, a case that started with some truly harrowing allegations within a family.
Exactly. A step-granddaughter's accusations against her step-grandfather. But while that human element is absolutely central, our focus today, based on the sources, is really on the legal battle that spun out from it.
A landmark battle, you could say. It forced Australia's highest court to grapple with a really core concept in evidence law.
And that concept is probative value. It sounds technical, maybe a bit dry.
It can seem that way, but it's crucial. It basically means how much does this piece of evidence actually help prove something relevant to the case?
Right. But the fight in IMM wasn't just about defining that term. It was about who decides it, the judge or the jury. And critically, what factors can the judge even consider when making that call?
Exactly. Like, should the judge, who's the gatekeeper for evidence, think about whether the evidence seems reliable, seems believable, or is that entirely solely the jury's job once the evidence is in?
That tension, that push and pull, it's really at the heart of how our justice system tries to work, isn't it?
Absolutely. How do you let in evidence that could be relevant, but also protect the accused from evidence that might be weak or unreliable or just plain unfair? And who manages that balancing act?
Understanding IMM v. the Queen is kind of a shortcut then to getting your head around that really fundamental dilemma in Australian law.
It really is.
So our mission today is to unpack the sources we have on this case. We'll look at the personal story that started it all, trace its path through the courts, which was quite a journey.
A real procedural saga.
Then we'll examine the clash of legal minds, the arguments that went all the way to the High Court. And finally, we'll explore the impact, the quite profound impact this one case had on evidence rules in Australia.
Particularly under the Uniform Evidence Law, which is the framework operating in many Australian jurisdictions. We'll be focusing on things like tendency evidence and rules about excluding prejudicial evidence.
It's a case that really shows how these seemingly abstract legal points have very real, very practical consequences in the courtroom.
Definitely. Consequences for how trials run and ultimately for how justice is pursued.
Okay, so let's start with that human core. The allegations against the defendant, known only as IMM in the proceedings, he was the step-grandfather.
That's right. And he was facing 4 serious charges: indecent dealing and sexual intercourse involving his step-granddaughter.
And the allegations described a pattern, didn't they? Not just isolated incidents.
No, the prosecution's case, based on the complainant's account, alleged a protracted period of abuse. It started, allegedly, when she was very young, maybe 4 years old, back in 2002.
And continued until she was about 11, so around 2009.
Correct. The sources detail specific alleged acts: touching in the bath, rubbing his penis against her, cunnilingus. It was presented by the prosecution as a continuing course of sexual abuse over a significant part of her childhood.
The formal charges, the indictment, was filed in February 2012, though there was a small change later on.
Yes, a procedural point mentioned in the sources. On the very first day of the trial, November 11th, 2013, the indictment was amended slightly. Counts 3 and 4 were swapped around.
Didn't change the substance of the allegations,
Mm-hmm.
but shows things can shift right up to the last minute.
Exactly. It highlights the sort of dynamic nature of these proceedings.
Now, the person at the very center of the prosecution case was the complainant. Her name was protected, of course.
Understandably.
Yeah.
And her testimony, her account of what happened, was described as the bedrock of the case. Both what she said in court and the accounts of complaints she'd made earlier to people she trusted.
It underscores the immense pressure on complainants in these kinds of cases, going through interviews, court appearances.
A difficult journey.
On the other side, you had IMM, the step-grandfather. His defense, naturally, contested the allegations. But crucially, for where this case ended up legally, they strongly challenged whether certain key pieces of the prosecution's evidence should even be allowed in.
That's where the legal fight really ignited.
And the first judge to deal with these evidential arguments was Justice Blockland in the Supreme Court of the Northern Territory. She was the trial judge.
Right. She presided over the initial trial and made those first pivotal rulings on what evidence the jury would hear. Her interpretation of probative value became the absolute focal point of all the appeals that followed.
As the case moved up, the legal teams became quite high profile. Representing IMM in the higher courts was Stephen J. Odgers, SC.
Yes, described in the sources as a really prominent figure in evidence law, a leading expert. He spearheaded the appeals, consistently arguing against the way probative value was being interpreted. He wanted judges to take reliability more into account.
And for the Crown, the prosecution.
At the trial level, and initially on appeal, it was Matthew W. Nathan, who later became an SC. He was instructed by the NT Director of Public Prosecutions.
And then in the High Court.
For that final stage, Brett W. Walker, SC, joined Mr. Nathan, SC, to lead the case for the Crown.
Having senior counsel like Odgers and Walker involved really signals that this case had become much bigger than its specific facts.
Oh, absolutely. It tells you straight away that a fundamental point of law was up for grabs, something with implications far beyond this one trial. The stakes were incredibly high for Australian evidence law generally.
And this didn't just land in the High Court overnight. It was, as you said, a saga.
A long journey through the system. It started, as these things often do, with the complainant making disclosures.
The sources mentioned complaints to family members, a friend. This triggered a police investigation around August-September 2011.
And then crucial child forensic interviews in January 2012. These early steps, the timing, the circumstances of the complaints, they often become really important later in the legal arguments.
Right. And based on that investigation, charges were laid against IMM in February 2012.
That's the formal start of the criminal case.
But even before the trial, there was a significant legal hurdle attempted by the defense.
Yes, back in February 2013, in the NT Supreme Court, IMM's first legal team, Ms. Armitage from Bennett Lawyers, was mentioned. They applied for a permanent stay of proceedings.
Which is a huge deal, asking the court to stop the trial before it even starts.
A very drastic step. Their argument was that the prosecution hadn't disclosed evidence properly, that it was inadequate and confusing, and that this amounted to an abusive process that essentially said they couldn't prepare a fair defense.
How did Justice Blockland handle that?
She heard the arguments and delivered her ruling late February 2013. She refused the stay. She did acknowledge some initial confusion with the prosecution's material, but she found it didn't reach the high bar of exceptional circumstances needed to stop a trial altogether.
So the trial was going ahead.
Yes. Her decision cleared the way. The focus shifted to ensuring fairness during the trial, rather than stopping it beforehand.
And that trial took place in the NT Supreme Court, November 2013, 9 days before Justice Blockland and a jury.
And the sources really stress that this trial was dominated by these intense legal arguments about what evidence was admissible.
This is where the trial counsel were really battling it out. Mr. M.W. Nathan for the prosecution, instructed by the DPP.
And Mr. T. Berkeley for the defense at that stage.
And two key types of evidence became the battleground. The first was this tendency evidence.
Right, under Section 97 of the Uniform Evidence Law, this related to something called the massage incident.
What was that alleged incident?
It was testimony from the complainant about something that allegedly happened after the period covered by the main charges, sometime in late 2010 or early 2011. She said that while she and another girl were giving IMM a back massage, he ran his hand up her leg.
And the prosecution wanted this evidence in. Why? To show a tendency.
Exactly. Their argument was this wasn't just some isolated, unrelated act. It showed, they argued, that IMM had an ongoing sexual interest in the complainant and a tendency to act inappropriately towards her. The idea being, if he had this tendency, it makes it more probable he committed the charged offenses.
But tendency evidence is tricky territory legally, isn't it? Highly prejudicial.
Extremely. There's a real risk a jury might just think, oh, he sounds like a bad person, or he did that, so he probably did these other things too, rather than focusing only on the charged offenses. It's called propensity reasoning, and the law tries to limit it.
And the defense counsel, Mr. Berkeley, jumped right on that danger.
He did. He called it bootstrap reasoning. His point was pretty powerful. The only evidence for this massage incident came from the complainant herself.
The same complainant whose credibility about the main charges was already being challenged by the defense.
Right. So Berkeley argued it was circular. You're using an unproven allegation from witness A, whose reliability is in question, to try and make witness A's other serious allegations seem more likely. It's like pulling yourself up by your own bootstraps, using the thing you're trying to prove as the proof.
So how did Justice Blockland rule on that one?
She heard arguments and ruled in August 2013 before the trial. She decided to admit the evidence.
Despite the bootstrap argument.
Yes. Her reasoning, which became absolutely central later, was that this evidence, if the jury accepted it as true, was capable of showing IMM's inappropriate sexual interest and a lack of inhibition towards the complainant. She also pointed to the timing, the strong temporal nexus connecting it to the charged period, suggesting an ongoing tendency.
And this is where her specific interpretation of probative value really kicked in.
Critically, following the established approach at the time, particularly from a NSW case called R.V. Shamouil, Justice Blockland assessed the probative value under Section 97 by assuming the jury would accept the complainant's account of the massage incident.
So she didn't weigh up whether she thought it was reliable.
No. At that stage, for admissibility, she operated on the assumption of jury acceptance. And on that assumption, she concluded it did have significant probative value, which is the threshold required by Section 97 for tendency evidence.
And she also had to consider prejudice, right? Sections 135 and 137.
Correct. Section 137 is the mandatory exclusion rule. The judge must exclude evidence if its probative value is outweighed by the danger of unfair prejudice. Again, applying that Shamouil taken at its highest approach, assuming acceptance, she found the probative value wasn't outweighed by the prejudice risk. So the massage incident evidence was in.
Okay, that was the first big battle. What was the second?
The complaint evidence. This involved testimony from other people, the complainant's friend, SS, her aunt, SW, her grandmother, SC, and her mother, KW. They testified about what the complainant had told them about the alleged abuse.
Complaint evidence is common in these cases, but legally complex. Hearsay issues.
Big time. Normally, what someone told someone else outside of court isn't admissible to prove the truth of what was said that's hearsay, but the Uniform Evidence Law has exceptions. Section 66, for example, allows evidence of a complaint if it was made when the events were fresh in the memory.
And the defense objected to this evidence coming in, too.
They did. They argued it had low probative value. They pointed to things like the complaint to the aunt happening after the complainant had been disciplined for something else. They suggested maybe leading questions were involved. There were also delays between the alleged abuse and when some complaints were made. All factors, they argued, that undermine the reliability and spontaneity of these accounts.
How did Justice Blockland rule on the complaint evidence?
She ruled on this back in July 2013. She decided to admit it. She found the complaints to the mother, KW, and the friend, SS, fit the fresh in memory exception under Section 66. The complaints to the aunt and grandmother were let in more as context to explain how the complaint to the mother came about.
And again, the crucial Section 137 balancing act, probative value versus prejudice. Did she apply the same Shamouil approach here?
Explicitly. The sources state she was very clear. When assessing the probative value of the complaint evidence for the Section 137 test, she was not considering its reliability or the complainant's credibility. She assumed the jury would accept these accounts as true, and on that basis, assessed their capacity to rationally affect the case. And she concluded, on that basis, that the probative value wasn't outweighed by the danger of unfair prejudice.
So, across both the tendency evidence and the complaint evidence, we see this really consistent approach from Justice Blockland.
Absolutely consistent. Interpret probative value, assume the jury accepts the evidence, don't get into assessing reliability yourself. That's the Shamouil approach she followed.
And that consistent approach, that refusal to weigh reliability at the admissibility stage, became the absolute core issue for the appeals.
It really did. It set up a direct conflict with other potential interpretations of the law, like the one hinted at in the Dupas case from Victoria, which suggested maybe judges should consider reliability.
Okay, so IMM is convicted at trial, presumably, because the appeals followed. First stop, the NT Court of Criminal Appeal.
Correct. The NTCCA. The bench was Justice Kelly, Riley C.J., and Heinley J.
And what did they make of Justice Blockland's rulings?
They upheld them. They affirmed her decisions on both the tendency and complaint evidence. They agreed with her approach and her conclusions.
Specifically on the tendency evidence, the massage incident.
They agreed it had the capacity to show sexual interest, and the timing was relevant. And crucially, they directly tackled the defense argument that it lacked probative value because it was uncorroborated and came from the complainant.
What did they say about that?
They essentially doubled down on the trial judge's reasoning. They said lack of corroboration or questions about credibility. Those are issues about the weight the jury might give the evidence. That's the jury's job. It doesn't affect the admissibility question, which is the judge's job based on the evidence's potential relevance if accepted. Mr. Nathan S.C. was still acting for the Crown at this stage, the sources confirm.
So 2 courts down, same result on the fundamental legal approach.
Right.
IMM had run out of options in the NT.
Right. So the next step was to seek special leave to appeal to the High Court of Australia.
And they granted it. which itself is significant.
Hugely significant. The High Court only grants special leave if there's a really important question of law or a conflict between lower courts, or if it's in the interests of justice. Getting leave meant that High Court agreed there was a fundamental issue here that needed resolving for the whole country.
So on to the High Court appeal. Full bench of 7 justices. We mentioned the powerhouse legal teams.
Yes, Odgers SC for IMM, assisted by Kristen Edwards, and Walker SC leading Nathan SC for the Crown, ready for the showdown.
And the arguments really crystallized here. What was the core pitch from IMM side, from Odgers SC?
Their main point was simple. The trial judge and the NTCCA got it wrong. They fundamentally erred, Odgers argued, by assessing probative value under Sections 97 and 137 by just assuming the jury would accept the evidence.
How did they justify saying that was wrong, based on the legislation itself?
Yes, they drilled down into the wording. They pointed out the dictionary definition of probative value in the Uniform Evidence Law doesn't say if it were accepted, but the definition of relevance in Section 55 does.
Ah, so the absence of those words in the probative value definition was key for them.
They argued it was deliberate, a conscious choice by Parliament. It meant, they contended, that when a judge assesses the extent to which evidence affects probability as its probative value, they should consider factors affecting that extent, including its apparent reliability or credibility.
Did they have anything else to back that up? History, policy.
Yes, they pointed to the Australian Law Reform Commission reports that led to the Uniform Evidence Law, arguing those reports supported a judicial role in filtering unreliable evidence. They also brought up the old common law Christie discretion, suggesting it allowed judges to exclude prejudicial evidence partly by considering its inherent weakness or unreliability.
And their practical point was?
If you don't consider reliability, weak evidence might get admitted because, if true, it seems probative. But its actual persuasive power might be very low because it's unreliable. And that low real value could easily be outweighed by the risk of unfair prejudice, like the jury misusing tendency evidence, especially when it relies solely on one person whose credibility is already the central issue.
Okay, a strong argument focusing on the judge as a safeguard against unreliable evidence. What was the counter from the Crown, led by Walker SC?
They defended the trial judge's Shamouil approach vigorously. They argued that, yes, the words, if it were accepted, aren't in the definition of probative value, but the concept is implicitly linked to Section 55's definition of relevance, which does have those words. So the assumption of acceptance flows through.
So for them, the judge's role is purely about potential.
Exactly. The judge assesses the evidence's capacity to affect the case if the jury believes it. Deciding whether to believe it, assessing credibility, weighing reliability, that's the jury's job, their exclusive territory.
And they argued the appellant's view would cause problems.
Big problems. Walker SC argued it would create an intolerably obscure confusion of function between judge and jury. Imagine judges having to hold mini-trials during admissibility arguments, trying to decide if witnesses are credible before the jury even hears them. Impractical, time-consuming, and undermines the whole trial structure, they argued. They also had a fallback. Even if reliability could be considered, the evidence here was still admissible anyway.
So the High Court had this fundamental disagreement laid out before them. Does the judge consider reliability for probative value or not?
That was the crux of it. A clear fork in the road for interpreting the Uniform Evidence Law.
And the decision, when it came, wasn't straightforward. A split decision.
A 4.3 split, which tells you just how difficult and finely balanced these legal and, frankly, philosophical questions were. Even the top judges in the country couldn't all agree.
So what did the majority decide? Which way did the precedent fall?
The majority came down firmly in favor of the Shamouil approach, the approach Justice Blockland had taken. The majority judges, Chief Justice French, Justices Kiefel, Bell, and Keene, with Justices Nettle and Gordon agreeing in separate judgments, held that when assessing probative value under Sections 97 and 137, the judge must assume the jury will accept the evidence, take it at its highest.
And their reasoning tied back to that link with relevance in Section 55.
Yes. They said because relevance under Section 55 is assessed on the basis if it were accepted, any assessment of the extent of that relevance, probative value, must logically proceed on the same assumption. They essentially said the omission of those words from the probative value definition wasn't significant. The link to relevance implied it.
So the rule is, judges generally cannot assess reliability or credibility for admissibility under these sections.
That's the core holding. Those matters are the province of the jury. The judge looks at the evidence's potential impact if believed, not whether it should be believed. They explicitly pushed back against using ALRC reports or common law history to read reliability assessment back into these specific sections, saying the statutory text as they read it prevailed.
Yeah. Okay, so the majority confirmed the method used by the trial judge was correct, but then came the twist regarding the actual evidence in IMM's case.
Exactly. This is where it gets, well, a bit mind-bending. Despite saying the judge's approach, ignoring reliability, was right in principle, the majority still found that the tendency evidence the massage incident should not have been admitted in this specific case.
How did they square that? If the approach was right, why was the outcome wrong?
Their reasoning was that even when taken at its highest, even assuming the massage incident happened exactly as the complainant described, that evidence still didn't meet the threshold of significant probative value required by Section 97.
So even if true, it just wasn't important enough.
Essentially, yes. They felt that while it might rationally affect the probabilities to some degree, it wasn't important or of consequence enough, either on its own or with the other evidence, to justify admission as tendency evidence under that higher significance standard.
So a strange result.
Mm-hmm.
Right method, wrong outcome on the tendency evidence. What about the complaint evidence?
They upheld the admission of the complaint evidence. Applying the assume acceptance approach to Section 137, they agreed with the trial judge that its probative value wasn't outweighed by unfair prejudice.
So the conviction likely stood based on the complaint evidence being admissible, even though the tendency evidence ruling was overturned. The exact final outcome for IMM isn't the focus here, but the legal principles.
Precisely. The key takeaway is the legal reasoning. And the majority added another layer of complexity, didn't they? This qualification about evidence being simply unconvincing.
Right. They said judges don't assess reliability, but evidence might be excluded if it's inherently incredible, fanciful, or preposterous. Okay, that probably fails relevance anyway. Or if it's simply unconvincing. What does that mean?
And that's the million-dollar question that's been debated ever since. How is simply unconvincing different from finding evidence unreliable?
Did they give any examples?
They mentioned one drawn from commentary. A very brief identification, maybe in fog or bad light, by a stranger. The majority suggested that even under their approach, where you assume the witness is trying to be truthful, the objective circumstances might make the evidence itself so weak, so lacking in substance that it's simply unconvincing. Maybe it barely has the capacity to rationally affect probabilities in a meaningful way.
So it's not about whether the witness is lying, but about whether the evidence itself, objectively, is just too flimsy.
That seems to be the idea. But the line is incredibly blurry. Critics immediately pointed out that this looks suspiciously like reintroducing reliability assessment through the back door using vague terminology. It's been called a new enigma in evidence law.
It feels like they tried to slam the door shut on judicial assessment of credibility, but left this little unclear window open.
That's a good way to put it. It shows just how hard it is to draw these absolute lines. And we shouldn't forget the dissent. Justice Gagler disagreed strongly.
He thought reliability should be considered.
Yes. He agreed the tendency evidence should have been excluded, but his reasons were closer to IMM's argument that assessing probative value under Section 97 should involve considering reliability. And even the concurring judgments from Nettle and Gordon J.J. took slightly different paths to the majority outcome.
So not a unified front from the High Court at all. More like a fractured decision reflecting deep disagreements.
Very fractured. But the majority view became the law. And that leads us to the legacy of IMM v. the Queen. How did it change things?
Fundamentally, it seems, it redefined the judge's role under the Uniform Evidence Law.
Massively. It significantly curtailed that traditional gatekeeping role where a judge could keep evidence out based on concerns about its reliability or the witness's credibility.
So, post-IMM, judges applying Sections 97 or 137 have to largely ignore their own gut feelings or assessments about whether a witness is believable or the evidence seems shaky.
To a very large extent, yes. The focus shifts almost entirely to the evidence's theoretical capacity to influence the case if the jury believes it, not whether the judge thinks it should be believed.
How does that translate into practice for lawyers in court?
Well, for the prosecution, it's often an advantage when arguing to get evidence in under these sections. They can rely on the judge having to assume acceptance. They save the arguments about credibility and reliability for their closing address to the jury.
And for the defense, trying to keep evidence out.
It's much harder now to argue, this evidence is unreliable, therefore its probative value is low. That door is mostly closed for Sections 97 and 137 admissibility arguments.
So what arguments can they make?
They have to work within the IMM framework, accept the assumption of truth, then argue. Even if true, this tendency evidence isn't significant enough, is 97. Maybe it's too remote, too ambiguous, its logical connection is weak. Or, for Section 137, argue that, even if true, its capacity to prove the issue is low, and there's a specific danger of unfair prejudice, not just that it harms the defense case, but that the jury might misuse it irrationally or be improperly influenced.
Or maybe try the simply unconvincing argument if the facts fit. Though that sounds tricky.
Very tricky, given its lack of clarity. But it's another potential avenue defense counsel might explore if the evidence seems objectively flimsy, regardless of witness credibility.
This whole shift, limiting the judge's role in assessing reliability, it must have caused some ripple, some concern.
Oh, huge ripples. The decision generated, and continues to generate, a massive amount of discussion, commentary, and quite a bit of critique from academics, lawyers, even judges. Many worry it weakens a crucial safeguard.
The safeguard against wrongful convictions based on unreliable evidence.
That's the core concern. If the judge, the experienced legal professional, can't filter out evidence that seems inherently weak or unreliable before he gets to the jury, does that increase the risk? Especially in cases relying heavily on one witness or historical allegations where objective proof is scarce. Critics argue it puts too much faith in the jury's ability to critically evaluate potentially flawed evidence without the judge's initial screening.
So IMM didn't really resolve the underlying tension in evidence law.
Not at all. If anything, it highlighted it. That constant tension between wanting clear, consistent rules, like assume acceptance, and needing judicial flexibility to ensure fairness in the unique circumstances of each case. IMM shows that even detailed legislation, like the Uniform Evidence Law, leaves huge fundamental questions open to interpretation, and the way courts interpret them can dramatically change how trials work.
It's quite something. A case stemming from such personal trauma ends up forcing a national reckoning on the very mechanics of evidence and proof.
It truly does. It fundamentally altered the judge's role in weighing evidence for admissibility, shifting much more responsibility onto the jury regarding reliability.
And as we've seen, it was far from a simple fix. A divided court, ongoing debate. The conversation definitely continues.
Absolutely. And hopefully this deep dive helps you, the listener, see how these technical legal battles shape the justice system you hear about every day. This wasn't just about legal definitions. It reshaped how truth is pursued in Australian courts, especially in the most sensitive cases.
Which does leave us with a final thought to chew on. If the judge, who sees and hears the witness directly, understands the legal nuances, is largely barred from considering reliability when deciding what evidence even gets to the jury, does that system strike the right balance?
How do we best protect the jury's role as the ultimate decider of facts, while still ensuring there are adequate safeguards against potentially flawed evidence leading to an unjust outcome, especially when liberty is at stake?
It's a critical question, and as you say, one the legal system is still grappling with in the wake of IMM v. the Queen.
A fascinating and incredibly important case.
Indeed. Thank you for joining us for this deep dive into IMM v. the Queen. We hope it shed some light on its complexities and its lasting impact.